the marriage takes place in India. Later, the couple moves abroad, and after the separation, one of them returns to India and files a case in Indian court. Now the question arises whether the Indian courts have jurisdiction or the foreign courts should decide the matter. Hello everyone, welcome to NRI Legal World. I'm Advocate Sonia Bhatti, a legal assistant at NRI Legal World. In modern times, many marriages involve non-resident Indians where one spouse lives abroad and the other lives in India. When disputes arise in such marriages, it becomes necessary to understand how Indian law deals with alimony and maintenance in NRI cases. In today's video, I will discuss an important issue in matrimonial law, that is alimony in NRI cases, and the legal complications that arise when spouses live in different countries. As per the Indian law, the duty to maintain a spouse does not depend on the place where the person is living. If the dispute has sufficient connection with India, then the Indian courts have the power to grant maintenance, even if one of the spouses is residing abroad. The right to claim alimony is mainly governed by the Hindu Marriage Act 1955, under which the court can grant interim maintenance during the pendency of the case and permanent alimony at the time of final decision. An important principle under this law is that either spouse can claim alimony or maintenance, which means both husband and wife are entitled to claim alimony or maintenance depending on the financial condition of the parties. This becomes especially relevant in NRI cases, where sometimes the husband is earning abroad, or in some cases, the wife is earning abroad, and the other spouse is living in India without any sufficient income. This becomes especially relevant in NRI cases, where sometimes the husband is earning abroad, or in some cases, the wife is earning abroad, while the other spouse is living in India without any sufficient income. Apart from this, maintenance may be claimed under Section 125 of the CRPC and under the Domestic Violence Act 2005. One of the most common problems in NRI disputes is deciding which court has jurisdiction to hear the case. In many situations, the marriage takes place in India. Later, the couple moves abroad, and after the separation, one of them returns to India and files a case in Indian court. Now the question arises whether the Indian courts have jurisdiction or the foreign courts should decide the matter in such cases. Indian courts can take the jurisdiction of the case if the marriage was solemnized in India, or if the couple last lived together in India, or if one of the spouses is currently residing in India. Even if the other spouse is living abroad, the court can proceed with the case once the jurisdiction of the case is established. The Supreme Court of India has clearly held that living outside India does not allow a person to escape from the matrimonial obligations. An NRI wife has the right to claim alimony or maintenance from her husband who is living in India if she is unable to maintain herself and the husband has sufficient means of income. The right to claim maintenance depends on the financial condition of the parties and not on the place of their residence. The purpose of these provisions is to ensure that a financially dependent spouse is not left without support after separation. While deciding maintenance, the court considers the income of both parties, their needs, their responsibilities, and their cost of living. It is a common misconception that only wives are entitled to claim alimony or maintenance, but the Indian courts grant this right to claim alimony or maintenance to both the spouses. If a husband is unable to maintain himself and the wife is financially stronger, then the court may direct the wife to pay maintenance to her husband. This situation may arise in NRI marriages, where the wife is working abroad and earning higher income, while the husband is living in India without any sufficient source of income. However, the husband must prove that he is unable to maintain himself. If the husband is capable of earning but refuses to work, then the court can refuse to grant maintenance. One common difficulty arises when one spouse earns in dollars, euros, pounds, or any other foreign currency. In such cases, the court decides maintenance on the basis of currency conversion. The court converts the foreign income into Indian rupees and then considers various factors such as cost of living abroad, taxes, liabilities, rent, and family responsibilities. Another important issue in NRI cases is that many times a spouse takes divorce from foreign court and assumes that the legal obligations in India have ended. However, in India, foreign divorce is not automatically recognized and it does not provide an easy escape from maintenance. The Indian courts will examine the foreign judgments to ensure that it was passed by a competent court and aligns with Indian law. If the foreign decree is found invalid under Indian law, the marriage will be still considered legally binding here, allowing the spouse to seek alimony. If an NRI spouse refuses to pay alimony or fails to appear before the court, then the Indian courts have the power to take any legal action against the NRI spouse, such as attaching properties or bank accounts located in India, issuing arrest warrants, or even issuing lookout circulars, which can lead to detention upon arrival at any Indian airport. In conclusion, the obligation to pay alimony or maintenance depends on the financial capacity, not on the geographical location. This video is for informational purposes only. It is advised to seek professional guidance before making any decision. You can contact NRI Legal World for any professional guidance. Thank you.